choice that this court can impose to secure the safety of this community. As the court noted, I did send exhibits. Defense has a copy of those as well. The state's exhibits are focused on what Rule 5409 actually requires. Pretrial detention is not a credibility trial. It's not a civil damages dispute, nor is it the studio's internal investigation, which is at best minimal and insufficient. It's whether the defendant is dangerous and if the court can impose conditions to secure the safety of the community. Thank you. And that's what the state will be focusing on. As I go through the state's exhibits, I will address some of the defendant's exhibits as well. I know the court gave the state an hour, so I would like to reserve some time for rebuttal as well. So the state's first exhibit is just the printout of Odyssey of the defendant's history here in New Mexico, which the state shows that there is none besides the underlying charges here. State's Exhibit 2 is the register of actions from the underlying case that we're here on, and just an event of showing when the criminal complaint was filed and the arrest warrant and when that warrant was served, along with the criminal complaint, which I will mostly focus on today. So I want to give some context, as there's a lot of defense exhibits along with the arrest warrant that is pretty lengthy. The named victims in this case, they started working on this show, The Cleaning Lady, in 2021. They filmed the pilot. They were asked later to come back for seasons 1 through 3, and that lasted until spring of 24. SL did the primary acting for seasons 1 and 2, although VL acted as well, and VL did the primary acting in season 3. Before season 4, there was a lot of back and forth with the children if they were going to continue to be casted in their role. After the 3 seasons, the boys were asked to audition, which is something they didn't have to do through seasons 1, 2, and 3. They had that audition here in Albuquerque in September of 2024. The lead actress in this show, her name is Elodie Young, and she was very close with the family. They went on vacations. However, she has not been compliant with this investigation. At that time of the audition, Miss Young asked the mother of the parents to come taken in a back room to do this audition. And then they left after the audition. Later, they found out that VL or SL was not going to be casted for the role that they've been in for the first 3 seasons. And only VL auditioned that day. Which, after they were released, the parents, I believe, posted that they were thankful for their opportunities, was very thankful for the show. Even though at that time the show was still using the boys, the victims in this case, to promote season 4. So eventually this brings us to the start of the investigation, which is the state's 2. There was concerns about abuse because the parents were being tagged in social media posts about the defendant's history. Because of those concerns, they asked their boys if there was any, with anyone, not just Mr. Busfield, but with anybody, if they were having any issues or inappropriate touching, anything like that. Or if they, actually, I think it was very clear that it was if they were uncomfortable in any situation. When the boys said, "Do you mean like with Uncle Tim?" Later, in November of 2024, the children were seen at UNMH. In UNMH, the doctor there is the one that referred this case, called the police, and reported it, which, as a mandated reporter, needed to. So based off of the doctor seeing the children and speaking with the parents and getting a medical history, they had concerns about grooming and the sexual abuse, and they reported it to law enforcement. APD later, I believe the same day, were dispatched to the parents' homes. They talked to the parents, and they talked to the boys. The boys did not disclose any sexual abuse, but did disclose signs of grooming, and did disclose that the defendant had touched them. Because there was no disclosure of sexual abuse, APD essentially closed the case. CACU said they weren't able to take the case. During this time, after the doctor visit, I believe, in November 2024, the kids then started therapy. I do want to note that in child abuse cases, I know the court is aware of this, is very typical that, well, one, officers are not supposed to speak with children, right, because of the power dynamic, and they want to make sure they're getting a reliable disclosure. So it's not uncommon that the kids did not disclose at that time or were ready to disclose at that time to a police officer that showed up at their house. Also, it's not best practices when interviewing a child according to our MDD structure by statute in New Mexico and across the country. Later, in February of 25, February 17th and 18th, there was a referral made to the SAG hotline about the boy that took over the role that the twins played. And that referral essentially said that a person saw the defendant kiss the boy while he was getting a haircut, that the defendant was intoxicated, and he had been drinking in his trailer as well. The next day, there was another referral made to the SAG hotline about how the defendant was alone with VL during this audition back in September. It's my understanding that the parents of the victims in this case did not make any of those referrals. Because of the liability and now these referrals, Warner Brothers did their own investigation and hired, I believe, outside counsel, Ms. Govern, to conduct this investigation. I know that is part of defense's exhibits. However, if you actually read those, the first one that was done in February, I believe it concluded in March, the beginning of March.
I did read them.
Thank you.
Long weekends.
They didn't interview any of the necessary witnesses to what was actually reported, which I think shows you the reliability of the investigation as well. After that investigation was concluded and there was a report, it's my understanding that Warner Brothers or this outside counsel was calling the parents of the twin boys. They went to talk to a civil attorney on how to address any communications, and I believe their attorney sent some concerns or a letter, I'm not too sure exactly, but sent some information about the boys. That's the second report that, as you see, is not done till September of 2025. In that report, there are concerns of sexual abuse, and nobody, the independent attorney nor Warner Brothers, ever reported this abuse. As we know in New Mexico, it's mandated that everybody, not just teachers, doctors, are mandated reporters, but everybody is. And so it is concerning that an investigator who is still investigating, even though they didn't talk to the kids or anyone relevant to that information, they still didn't report any abuse despite this letter. And they found, in both findings, they found that there was no wrongdoing, essentially, even though their investigation was pretty minimal and the witnesses needed weren't ever interviewed. Which now brings us, because that report was done in September of 2025, which now brings us to how the boys then disclosed the sexual abuse against the defendant. It was during therapy, not the parents, to a neutral party, that SL described sexual abuse by the defendant, and VL disclosed inappropriate touching. SL even disclosed in therapy that he was mad at his dad because he thought he knew that it was going on because he had the iPad or these links to watch his children. The therapist then made a referral. I believe that then a doctor saw the kids at Journey Pediatrics. Also, the therapist, throughout their time, had diagnosed one of the boys, SL, with PTSD because of these issues. In September, SL was seen by a doctor at Journey Pediatrics, who also reported or indicated sexual abuse in that visit and treatment of the children. I also want to make something clear that the doctor at Journey Pediatrics in September of 2025 was the one who reported the concerns to CYFD. The mother did not call CYFD. It was the doctor. I know that the court is aware of this. However, it is the norm in child sexual abuse cases that kids delay disclose, and for many reasons that are also present here in this case. About 80% of children delay disclose. That's not only known nationally and supported by literature, but also in my experience prosecuting these cases. So it is not abnormal, but the norm on how the kids reported. It's also very normal that kids give a little bit at a time to test the waters to see what happens. As reported in their forensic interview, they talked about being scared. They talked about people being mean to them. And so that also shows why a delayed disclosure is typically made and supported by the literature. In October of 2025, October 31st of 2025, after this investigation started again with the detective on this case, during those safe house interviews, again, to a neutral third party, the boys disclosed the abuse. I also want to make this clear that the boys never said that the abuse happened when they were alone with the defendant. They actually indicated that some people were around and some people would leave. They never said that this happened when they were alone with him. So these arguments coming from defense and the exhibits provided don't add up with the testimony and with the kids' disclosures that they have given. The boys also disclosed how it made them feel and how uncomfortable they were. What's also noticeable is that when SL discloses the timeline of abuse, it matches up with the other witnesses, including his set teacher, the person that supervised him while on set, changed, that his behavior changed, that he didn't want to act anymore. He didn't want to be around anymore. So this isn't just coming from the child, but this is also coming from witnesses. His behavior corroborates what he is saying as well. What is also important and throughout this investigation is what the defendant told police. He stated that he would tickle and pick up the boys, even though he knew that with Warner Brothers, they weren't allowed to be alone or touching. But then later, he contradicts himself and says that he doesn't really even remember the boys, after he's already said he did tickle the boys, and it's highly likely that he did touch them. Not sexually, but touch them by tickling them in all of the other grooming aspects that the kids disclosed. So his own statement contradicts the letters really provided on defense's behalf. Something notable also is the defendant says that the victim's father very much encouraged the behavior to hug Mr. Busfield, and he felt uncomfortable, but he never told the dad to stop, that it's not, that we don't hug children, that we don't touch children. He never told that. He never said that. As you see in State's Exhibit 2, several witnesses were also interviewed. Lauren Trujillo and Taylor Trujillo, that also discussed that the kids weren't always supervised. And even the set teacher, Lee Lewin, she also said that she was in the main room where there wasn't cameras, but that she confirmed the iPads and confirmed there was a lot of people around, but that people lose track. There's a lot going on in these sets. I want to mention Danielle Vigil and Christina Carr, because now it seems like they're unhappy after they already gave a statement to police on how it was portrayed. The court knows that not everything in every interview is word for word in documentation. What is relevant to the allegations is what is usually in a criminal complaint arrest warrant. Especially this warrant was already quite lengthy. However, there is concerns that people have now got to those witnesses since speaking with police, and now they're writing affidavits on behalf of the defendant, suggesting that what they said wasn't true. So as for the dangerousness prong, State's Exhibit 2 shows that. Criminal sexual contact of a minor is a mandatory serious violent offense, which is different from necessarily dangerous, and here might not seem violent in the literal sense, but any deal of harm done to a child, especially when it comes to sexual abuse, the deal of physical harm, the emotional harm is long lasting. And that behavior when grooming children, engaging in grooming and engaging in sexual abuse, is inherently dangerous. The state does have other arguments to make on dangerousness when it comes to the defendant's history. And I want to make clear that nowhere in the case law and nowhere in 5409 or the F6 factors say that the defendant's history has to be charged criminal conduct. In fact, it can be unknown conduct at the time and what's presented to the court, which is laid out also in State's Exhibit 2 about prior allegations, and in State's Exhibit 3, 4, 5, and 6 of other victims and the victims that we already knew, have reported previously, have come forward and gave a statement as well. So the first allegation, a 17-year-old disclosed that the defendant had sexually assaulted her, tried to serve her alcohol, and groped her. Unfortunately, at that time, what she reported is that the cops said that he wasn't going to be there much longer, and there was nothing that they could do, and there was later a civil suit filed in which the defendant later settled. That was back in 1994, and that victim was 17 years old at the time. Something I want to know about the kids' disclosures and all of the disclosures that were made prior and have been made since, there's a pattern. The pattern is all touching. There's a pattern of his conduct. Also, the boys' disclosures in this case, they were detailed, they were visceral, they were also not exaggerated, which I think cuts into defense's argument about what they think this case is. I say that because I think it is important when we're filing PDMs on these types of cases. If defense wants this court to believe that this is all about money, wouldn't it be easier for a child and all of these previous victims to disclose more than criminal sexual contact? It's shocking that all of the victims that have reported all report a similar pattern from the defendant, and they're not exaggerated, which makes the evidence in their disclosures credible. The second allegation occurred in March of 2012. It's my understanding that, and I believe this victim has called law enforcement as well, but essentially he had...
Is this one of your exhibits?
Yes, it's in States 2.
Oh,
Just,
States
yeah.
2. Okay.
The last page of the arrest warrant, Your Honor. Or the second to last page. In March of 2012, a 28-year-old accused Busfield of touching her inappropriately in a movie theater. She reported to police, and the prosecutors felt like there was not enough evidence to move forward, and he said it was consensual. Again, that pattern of touching, of criminal sexual contact, is important for the pattern of the defendant, especially when it comes to the F6 factors, which I will get to. With the reports, even from the two victims I just spoke about, also shows that the defendant is dangerous, along with States Exhibit 3, 4, 5, and 6. Rachel Wright was that victim, the 17-year-old victim. That's what States Exhibit 3 is. I think what's also notable is that she felt, and you can see this on the second page of States Exhibit 3, is that she felt like he was manipulating her throughout the process as well. States Exhibit 4, these victims reported soon after, but this had happened a long time ago. The victim in this case, and I believe this has been reported to APD, but I think has been reported to Sacramento PD as well. That victim was 16 years old at the time. She was working at B Street Theater, a theater in Sacramento that the defendant and his brother started. I I believe she was interning or working there, and the defendant again touched her, kissed her, and then stuck his hands down her pants, touching her genitals. Their report is that the defendant's brother and the defendant came to talk to the victim and the victim's dad to not report it, and that he would get therapy, which the family agreed with, and nothing went further in that case. State's Exhibit 5 is from the defendant and his wife's personal assistant. They worked, I believe, through the May of 2017 until 2019. And she mostly describes how the defendant was inappropriate, intimidating, that there was a lot of, this position of authority that we've kind of seen play out in this case and all of the other victims that have come forward, and had made comments to her about the way she acted and that he might have a crush on her if she continues that behavior. So there was concerns of inappropriate conduct with her as well. State 6, Claudia Christian, who is an actress, she has reported that when they were filming The Strays, the defendant and her, she was already casted as an actress, and during the show, they were running lines, which was common, and they went to his trailer. She stated that once she got there, he was alone, and almost immediately after she entered his trailer, he forcibly grabbed her and threw her against the wall, and started kissing her, and he had an erection. And she ended up running out and telling I believe, assistant director to keep her away from Mr. Busfield. Which those allegations also go to the defendant's dangerousness. So I think by clear and convincing evidence, the state has met the dangerousness prong here in this case. Not only because that people are coming forward and reporting this, but the way they're reporting, how the pattern is consistent, and the power that the defendant has had over all of these victims, and the position that he's played that role in. When it comes to conditions of release, the court focuses on the F6 factors. The first factor, the nature and circumstances of the offense charged, and whether that offense is a crime of violence, which the state has gone through and argues that we have met that, the nature and circumstances of the offense charged, and that this is a crime of violence. The weight of evidence against defense. It's still the state's position that the evidence is strong. The boys' allegations are supported by medical findings and by their therapist. And again, their accounts were specific and not exaggerated. I want to touch on this a little bit more due to defense's filings. Defense, first couple exhibits are about the victim's parents and their criminal history, essentially saying they have a motive to lie because they have a past, because they have had a conviction and had some other lawsuits. The parents aren't the victims in this case. The parents are not the ones making these allegations. the kids didn't even disclose to their parents. They disclosed to a neutral third party, two of them, their therapist and a doctor. To believe, well, first, during criminal proceedings, there is no money attached. They don't get money at the end of this process. For a victim to go through this is not an easy process at all. Defense makes allegations about how much the kids were acting, which is, they're quite a bit off, but yes, they were making money for working. And what makes more sense is because they weren't with Mr. Busfield anymore, is to continue to get acting jobs if they were about money. Not to come through the criminal justice system, because it's not guaranteed. Neither is a civil case, and there's no civil case that has been filed by the parents at this time. I think that argument doesn't make a whole lot of sense when looking at the facts and what we're here on today. We're here about what the kids are disclosing, what the crime charged is, and if there's conditions that the court can set, not about the parent's history. And essentially, what they're saying is that anybody that has a criminal history can never be a victim because they're going to lie. But this isn't about the parent's history. This is about the defendant and the defendant's history and why he won't comply with conditions of release.
Actually, I do have a question.
Yes.
With regards to the parents, there's reference to the parents having an attorney, and the attorney gave them the advice to seek out medical intervention in this case. Has there been a lawsuit filed, or is there plans to file a companion civil lawsuit?
It's my understanding that they are not filing a civil lawsuit. The attorney they talked to about what to do was a friend of the families. I believe one of their employers, actually. What do we do in this circumstance? It was more as friendly advice, not let's start this civil lawsuit and then...
Okay. That part wasn't clear.
Yes.
That it was a
yes.
friend. Okay.
I wanted to make that clear. And there is no civil lawsuit filed.
Okay.
Sorry, Judge, I'm just getting back to my notes. I think what is also important when it comes to the weight of evidence against the defendant is that we have corroborating evidence. That the defendant, once the defendant started directing SL, that's when he didn't want to act anymore or be on set. That there's been bedwetting, nightmares, that other witnesses have also seen a big shift, despite defendants' affidavits. There are still witnesses that say, no, these kids, SL particularly, had a change in behavior after Mr. Busfield started directing him. I know I stated this, but I do want to make this clear because so many of the affidavits and so many of the letters of support say this could not happen because there were so many people around. The kids didn't say it happened when they were alone. And we see every day that sexual abuse with children can happen in front of several people. We know that from well-known cases. We know that from the Larry Nassar case, where he was physically and sexually abusing his patients in front of their parents. We know that these events and these crimes can happen in front of other people and them not recognize or see what is going on. The history and characteristic of the defendant, like I said, there's nowhere in the rule that says there has to be known criminal convictions, but a history. As I've laid out, the pattern, the reliability of how almost all of the reports of sexual abuse against the defendant are all very similar and not exaggerated. that his history spans back 30 years, back to the 1990s. And this characteristic of the defendant, the state would argue, possesses a high risk, a very high risk of offense. Because either people are going to continue to ignore it, and they're going to continue to believe that the defendant could never do anything like this. And that he would never do something like this, which I'll get to his letters in a moment. I think what's also important to note is the defendant's testing that he did, this ABLE testing. When it really comes to risk assessment of offenders, which that testing really has nothing to do with risk assessment, which would be more appropriate for this hearing when the court's considering conditions of release, really has to do with if he's at risk. He's already been named in a lawsuit early on, back in the 90s, and the behavior hasn't stopped. In fact, it's continued, as we see in these reports and other allegations, and he's continued to get away with them. And so the ongoing risk of the defendant reoffending or continuing to do what he has because of the power of his position shows this court that he does have the likelihood that he could reoffend. The nature and seriousness of the danger to any person or the community that would be posed by the defendant's release. Pursuant to State v. Begay, I have the case if the court wants it, but I'm sure the court is familiar with it. The court must determine if the risk of releasing the defendant is one the court is willing to take in light of everything presented. This comes down to a simple question: is the court confident it can set any conditions of release that, if violated, will be reported or can be monitored? And the answer here is no. When it comes to this type of case, these types of charges, child sexual abuse, there's no way the court can set conditions to make sure the defendant won't be around children, won't continue to engage in this behavior, continue to have witnesses provide new affidavits in lieu of what they've already told police, and a lot of other concerns, even a flight risk as well, and his compliance. I want to note the defendant's 87 letters of support. I think this is important when the court is considering conditions of release. Because how is the court knowing that there's, at the very least, 87 people supporting the defendant, and in these letters, all saying, I knew he would never do this, he could never do this, and he would comply with conditions, and I would allow my own children to be with him? How can the court set conditions knowing that all of these people blindly trust the defendant's word and not knowing any of the evidence that he's actually going to comply? It's only because of their relationship. And that's the concern here in child sexual abuse cases. We do have a great pretrial service division here in this courthouse, but they can't monitor these charges, the concerns for this court, the concerns that 87 people already have made their minds up that the defendant didn't do this and would never violate conditions of release. That shows you that so many people in the community aren't ever going to disclose if there is a violation. And what that also shows is that they don't believe when victims come forward. And that has been shown throughout the history of the defendant's 30 years where these allegations have come out. So although, yes, there's some argument that he has all of this support. That's great. People should have support. But I also think it shows the power that the defendant has over the community. This position that they blindly believe him and that they won't report any violations to this court. I wrote this in my motion that also when it comes to conditions of release, the defendant was notified about his warrant, or at least we knew he was notified because his attorney called our office on the 9th. That warrant was issued for his arrest on January 9th. Mr. Dodd called Miss Lyon asking her to cancel the warrant and that they wanted to avoid the extradition process so he could get here sooner and deal with what's in front of him. Miss Lyon told Mr. Dodd, we are not canceling the warrant, despite the email that they provided to this court saying we never responded. We had already responded prior to that email, that we weren't canceling the warrant and he can get here however he can. What's important when it comes to conditions of release is how he acted during these 5 days before he turned himself in. The state isn't concerned about the statement he made. What the state is concerned about is that, again, the defendant is using his control in deciding when he wants to comply with an order. That order did not say, sure, turn yourself in 5 days. That order was for him to be arrested and him to come deal with these charges. Instead, he drove 2,000 miles, as he stated in his statement to TMZ. He got a polygraph. I believe, at least from the report, it said it was done on the 16th, the same day he turned himself in, and that he did this ABLE testing, which I believe was the day prior. I'm not saying that defendants don't have a right to fight their case. They do, and they very much should. But what that shows, that behavior and that conduct, that shows this court, is that the defendant is only going to comply when he wants to, when he's ready to, when it's most comfortable for him. That's what the defendant has already showed this court. Not that he's going to comply immediately with these conditions that the court could set. Further, this court cannot they cannot have pretrial do house calls. They cannot confirm that he is not around children. GPS is not going to tell this court if he is around children or talking to witnesses or anything that the underlying facts of this case is the concern of. This is not a drug case where pretrial services can test them to make sure they're still not using substances. What pretrial services can do is nothing that satisfies the safety of the community. This court, and I do want to note this, that the defendant made through counsel an argument that this motion should also be denied because we routinely file these PDMs. As the court knows, I prosecute child sex abuse cases, child death cases, child physical abuse cases, the people where conditions can't be set. So yes, it is routine in SVU because of these offenders, because of how dangerous they are, how manipulated they are, how that no one wants to believe children when they actually disclose, when people point out anything else they can to actually discuss the facts of this case or the cases. That's why PDMs are filed. And this case is no different. And the state believes that there are no conditions that this court can set for this defendant and defendants similar in his position. I think I've addressed F6E, the factors to indicate if he may or may not commit new crimes. I think His history speaks for himself. I think his position and how he wants to control the narrative and how to comply also shows how he will perform on conditions of release, or if there is a likelihood he could commit new crimes. The last factor is if a PDM has ever been filed before. There's no other cases here in New Mexico, a PDM is not, and so that factor should weigh neutrally. Briefly, I do want to just discuss the ABLE. Can you tell me the time I have?
Yeah, you've got 15 minutes left.
When it comes to the ABLE and the polygraph that defense has provided. Polygraphs, although allowed here in New Mexico, I would ask the court give less weight to, because we don't have raw data. Defendant didn't provide us with that. And the polygraph does not address what this hearing is about. Those questions had nothing to do with if he was going to apply with conditions of release. And a PDM hearing isn't really for a mini trial to decide the truth about what happened in this case. So I would ask that the court give limited weight to the polygraph and also how that was conducted and when and what that really shows about conditions of release. When it comes to the ABLE testing that was also done before he turned himself in, really this is to show, it does not show anything about their risk. It shows if they are sexually interested in a certain type. And essentially, they're looking at a computer screen of photos. It's very subjective. It depends on the questionnaire that was presented before, which the state does not have. And it's also, there's a lot of debate about the reliability of the ABLE testing. And again, it doesn't address any conditions of release here in this case. It's really a risk factor to sex offenders. And if he's claiming he's not a sex offender, I'm unsure why an ABLE testing has anything to do with this, even to show that he is not attracted to minors. I think what is important here is not necessarily about what the ABLE test provides, but that the defendant had an opportunity to do these things. It doesn't matter who he's attracted to. We know that all different types of sex offenders prey on different demographics of people. It doesn't have to be children. They do not have to be a pedophile for this to happen. It's the opportunity that the defendant had and has had over these last 30 years and with the time that he had with these victims in this case. Just briefly, I want to address that the attacks on witnesses' characteristics don't eliminate the risk of the defendant. That the studio's investigation really has nothing to do with the criminal investigation, and I think the court has seen the minimal investigation that they have done. And most importantly, when it comes to conditions of release, that this court can't set any conditions that is going to protect any other child, any other victim, any other witness from reporting or continuing reporting. The court can't set conditions to secure that. There's no way anyone can monitor that behavior. And what we know is the defendant has a history, and that's what the court should consider, is the facts, not all the speculation that the defense has provided for their argument that has nothing to do with conditions of release. Thank you, Your Honor. I'll save my last couple minutes for rebuttal.
Cool. You'll have time. Thank you, Ms. Brandenburg. Okay, Mr. Dodd.
Thank you, Your Honor. First, I'd like to let the court know we've supplied a binder for the court that has all of the exhibits and everything in it. It's
okay. I saw it.
Yellow
I got my
binder
own.
there. Perfect.
With my notes.
Secondly, I'd like to apologize for consuming what I imagine was a lot of the court's time this long weekend.
It's okay.
So I'd like to tell the court how we intend to structure our hour in this case. I'm going to give some brief introductory remarks, followed by one witness. And then Ms. Fairberg will take over for argumentation. Okay. I would ask at this time that the court accept defendants' exhibits A through BB.
Yep, they're all admitted.
As reliable. Thank you. Ms. Brandenburg just referred to this mountain of evidence that the court has before it as speculative. This is not speculative. What the court has before it is, I would estimate, probably the most comprehensive response to a motion for pretrial detention that has ever been filed in this state. And it was amassed in 7 days. 7 days, and that's the evidence that we were able to put together. Every aspect of the state's case is flawed. Every aspect of the state's case is questionable. I don't need to tell the court this, but my client is presumed innocent. As he sits here today, he is an innocent man. And I have significant concerns about the prosecution talking as if he has already been convicted. She referred to the people who wrote letters of support. She said, quote, "They don't believe when victims come forward." It's our legal system that starts from the position of saying, we don't believe. It must be proven beyond a reasonable doubt. The question before the court today is the court going to hold Mr. Busfield in custody pending the trial in this matter, if we ever get that far? There has not yet been an indictment. We have not received a target notice.
Oh, it's going to grand jury, right?
Yes, Your Honor.
Yeah, okay.
We have not received a target notice.
Do you guys have a date for that yet?
I do, but if the court wants it, I'd ask for it to be in private to,
Okay.
to comply.
Okay.
The state's arguments are based on a fallacy. Their fallacy is, heads we win, tails you lose. You don't bring any evidence to pretrial detention hearings, you're dangerous. We're going to detain you. You bring a bunch of evidence, that's how powerful he is. That's how terrible he is. We detain him. That's their argument here today. I want to compare the state's presentation of evidence with the defense presentation of evidence. 6 exhibits. 6 exhibits. That's what the state has brought. They've brought Odyssey printouts, and then really the meat of their case is a criminal complaint and several police reports, all authored by the same person, Detective Brown, the person who was in charge of this investigation. And as we make clear in our papers, there are significant concerns about what Mr. Brown, or Detective Brown, includes in his reports and doesn't include. Ms. Brandenburg, during argument, stated that, oh, well, only what's relevant goes into the criminal complaint. And Ms. Feyerberg is going to play this for the court later, but when the children were first talked to by the police in this case.
The 2 audio clips?
Correct.
Thank you for sending those. I did listen to those.
Great. As the court is well aware then, it wasn't simply that the children did not disclose sexual abuse. They flat out denied it. They said, no, it didn't happen. The fact is that the criminal complaint in this case is slanted. It is slanted to bolster the state's case and omit exculpatory evidence. The evidence that we brought to court, the evidence favoring Mr. Busfield, cannot be used in the way the state is claiming. Oh, somehow bringing evidence should be weighing in their favor. And the court cannot indulge this kind of argument. Evidence favoring Mr. Busfield can only be interpreted one way, in his favor. It would turn our justice system upside down to say that if somebody defends themselves, it must mean that they are dangerous. It must mean that we should hold them in custody, because the ultimate result is that every single person would be held. The last thing that I want to talk about in my opening is this self-surrender process. Ms. Brandenburg said that it was 5 days. It was 3.5 days, Friday evening to Tuesday morning. All actions that Mr. Busfield took during that time were at my direction to mount a defense. I tried to negotiate with the district attorney's office. I told them, he's coming here. He'll come here. We do not need to go through a month or 2 month long extradition process. He'll be here. And they told me, you can do whatever you want. We're not going to do a thing. So I brought him here. He drove 2,000 miles in 2 days. 2 days. And then we spent one afternoon doing a psychosexual risk assessment and one morning doing a polygraph. And then we self-surrendered at MDC. I think that shows how seriously Mr. Busfield takes this case. It shows he is ready to fight this case, and he is going to fight this case, and he is going to do it with respect for the law. An arrest warrant is not an order to a defendant. An arrest warrant is an order to the police. But my client, knowing that the police were ordered to arrest him, wanted to confront these allegations. So, Your Honor, at this point I'm going to call our first witness, our only witness. And then Ms. Feyerberg will make argument. And so at this time, the defense calls Alan Caudillo.
All right, good afternoon, sir. I'll swear you in. Do you swear and affirm that the testimony you give is the truth, the whole truth, nothing but the truth, under penalty of perjury?
I do.
Thanks. Please have a seat. Have you testified before?
I haven't.
Okay. So everything's being recorded in this microphone here, so please just be sure to speak loudly and clearly into that. The
I
attorneys
can
are
sit, right?
Yeah, and the attorneys are going to ask you some questions now.
Okay.
Okay, Mr. Dodd.
Thank you, Your Honor. Could you please state your name for the record?
Alan Cadillo.
And Mr. Cardillo, what do you do for a living?
I'm a director of photography on movies and television shows.
What is a director of photography?
Director of photography supervises all the photography for a project, hires crew, and in television shows guides guest directors through the process of that particular show.
And as a director of photography, do you work closely with the director on any given project?
Yes.
And how long have you worked in the film industry?
Over 35 years.
How many projects have you worked on?
Hundreds of projects.
How many days of filming do you think you've done?
Thousands of days.
And are you a member of any unions?
I am. I'm a member of the International Cinematographers Guild, Local 600, and of the Directors Guild of America, TGA.
And have you worked on any projects that I might have heard of?
Yeah. Probably the biggest project I worked on was The Hangover. I was one of the directors of photography on The Hangover.
Okay.
And Hangover 2.
Now, I want to turn and I want to talk about The Cleaning Lady. Did you work on a television show called The Cleaning Lady?
I did.
And what was your role on The Cleaning Lady?
I was the lead director of photography for seasons 1 through 4.
Were there more than 4 seasons of The Cleaning Lady?
No, it was canceled after the 4th season.
So you were the lead director of photography for all 4 seasons?
Correct.
And as the lead director of photography on The Cleaning Lady, did you interact with Timothy Busfield?
I did. Tim came to us season 2 at the end of the season, episode 11. So he came as a guest director on that. And then they brought him back seasons 3 and 4.
For seasons 3 and 4?
Yeah, correct.
Okay. Why did they bring him back?
He was well liked by the cast and the crew. Did an excellent job, and they needed somebody to help supervise future directors who were going to be guests to help them do that process for season 3 and 4. So he was a producer director for those last 2 seasons.
Okay. Yeah, what does that mean, being a producer director?
Part of it is really he's helping to make sure that each guest director comes in, understands the process, and knows the ins and outs of working with the cast, understands the quirks of the crew or locations, and then also he supervises editing and music things and casting to some extent. So he's there to be a guide for the series.
And so just so I'm clear, Mr. Busfield was involved with The Cleaning Lady for season 2, episode 11, and then all of season 3 and 4.
Correct, yeah. He was directed 1 episode season 2, and then I think 2 episode 3 and 2 episode 4.
Okay, so he directed a total of 5 episodes.
I believe it's 5. Yeah, I believe it was 5.
Now, have you reviewed the criminal complaint in this case?
I did read it. I saw it on Deadline. Yeah.
And are you aware of the allegations by, I want to refer them by their initials, okay? Let's just make sure we do that, okay?
Mm-hmm.
Are you aware of the allegations by SL in this case?
I am, from that complaint.
And you know when I refer to SL, you know who I'm talking about, correct?
I do.
And based on your review of the criminal complaint, what is your understanding of the nature of the allegations in this case?
I'm sorry, I don't. What understanding of the nature, like what happened?
What does he say happened?
Oh, he said that Tim touched him inappropriately on set.
Okay. And was that during filming? Do you know?
It seemed to me from the complaint he was saying it was on set while we were filming. He'd said, I think I remember reading, he said something like, when he cut, he would come in and that's when he would do it.
Okay. Now, as the director of photography, did you work on every episode that Mr. Busfield directed?
I did.
Did you work closely with him on each of those episodes?
Yeah, absolutely. I work very closely with all of the directors, and that first episode he was a guest, so it was one of my jobs as we've been there for 2 years, is to make sure he understands our process, gets to know the cast and crew, sets and things like that. So we worked very, very closely. I never left his side.
Okay. And so is it possible that Mr. Busfield inappropriately touched SL on the set of The Cleaning Lady?
No.
Why not?
Film sets may seem chaotic if you're an outsider, but everything we do is incredibly regimented. We're all a group of professionals who all know what they need to do, a lot of times without being told. And at any given time, if the child was on set, there was at minimum of 10 people there on the set with them. It's just how it works. There's 2 cameras, 2 camera operators, 2 focus pullers, 2 boom guys, a prop person, a hair and makeup person, the studio person would usually be there, the first assistant director, 2 dolly grips. And that's for every take, for every shot, always, especially with the children, because we had such a limited amount of time with the children. If they were on the set, we would bring them on and start rolling. Because once the rules are such, if we go over, that's it, we're done, and we have to not shoot the scene and go over and spend a ton of money. So every second of their time was regimented. We often wouldn't even rehearse with the children, especially with these young guys. They weren't the best actors. They were perfect look for the show, but they weren't the best performers. So we would rehearse with the stand-in, which was an adult, and then we would just bring them in and have them do the part. So they a lot of times they wouldn't even be there for rehearsals.
I want to shift and talk now about these boys and their parents, okay? Mm-hmm. During filming of The Cleaning Lady, did you get to know the boys and their parents?
Yes.
And how much did you interact with those 4 people?
Well, not a ton, but I always take care. I always make sure I get to know the cast very well, and the crew as well, but the cast, and try to get to know the parents of children when they come on the set, so they feel comfortable, know that we're there taking care of their children, and they feel comfortable. So I got to know them. I would see them when they would come to set. Okay. And we did occasionally see them after, at rap parties and things like that.
Rap parties?
Well, when it's over, you go and have dinner and to celebrate the season.
Great. Okay. The boys' parents, what were they like?
I think the mother was she always seemed very, very nervous and anxious and very quiet and reserved. The father was very aggressive, really very talkative, but didn't really seem to say much, just very aggressive, very kind of alpha male sort of guy. It seemed like a typical sort of aggressive set parent.
Was there anything that the father did that seemed odd to you?
Yeah, yes. He was overly aggressive with me. I felt like he was always trying to be my friend or wanting to, go do things after work or go have drinks or golf or, things like that. And I wasn't really that interested in that. Something he did do that for me that made me uncomfortable, and it was addressed earlier, was that he would have the kids, if we came on set and, if I was giving a high five to the kids and they missed it, the father would go, hey, go give Mr. Allen a hug. And that made me feel uncomfortable because I would never let my kids just force my kids to hug somebody. There should be something that they want to do, or it's, mutual, not, say you have to hug somebody. So that really kind of was like nails in the chalkboard for me, like to force one's child to hug somebody they didn't really know.
Did it seem like the father was trying to force relationships? Like between you and the children and things like that?
Yeah, I mean, it did. I felt like, he wanted, honestly, I don't think he understood what I did. I'm not, a director of photography is a below the line person. We're not bosses. I'm a boss of my group, the lighting, the grip, and the camera people, but I'm not a decision maker. I don't cast. I don't do things like that. And I think he might have misunderstood what I did because people would listen to me on set because I'm giving people, put that light there, put that camera there.
You mean you seemed important?
I seemed important, and I think he thought, okay, then I better
Drive a relationship.
better make sure that he's got a good relationship with that guy.
I see. Now, I want to ask you about the kids leaving the show. How did the kids end up leaving?
Well, a couple things happened. Well, several things happened. One, because of COVID, our schedule got extended. So when we started the project, when they shot the pilot in 2021, we didn't really even start shooting the series until, I think, the summer of 22. So it's a year later, so these children have already grown up. And this show takes place in, really, I think the whole series, all 4 seasons of the show, I think take place in like a 1 year or maybe a year and a half time. It was really, story-wise, it was compressed. And so because of, circumstances, we had a big writers and actors strike, so we ended up pushing. And the kids kept growing, so, by the time we started really shooting, by the time we got to season 3, they had grown different heights, there were different heights, and their facial structures had changed, right? So they just didn't look like they did at the end even of the prior season. And it became, I think, clear that we needed to make a change. It wasn't my decision, but, the studio decided that.
Okay. And have you heard about how the parents took it when they were informed that the children were not be coming back?
I did hear. I was not there when that happened because we had already finished. That happened after we were starting season 4.
Okay.
Prepping season 4, not shooting. And I heard that they took it very badly, that they were very, very upset.
Now, I want to ask you just one additional line of questioning. How much pay did the kids get for each episode?
I honestly can't say it. I'm not, like I said, I'm the working guy, not the producer.
Sure.
I had heard that it was, like around 50 to 60 grand, something like that.
Per episode?
Per episode. I think that was between the two.
Like combined?
Combined, yeah.
Okay.
Again, I'm not a producer. Nobody ever gave me a budget, so I don't know.
But that's what you'd heard?
But that's what I heard. And that doesn't seem out of bounds for what that rate is for what actors make.
Okay. And how many episodes were there in season 1?
Season 1 was 10 episodes.
And how many episodes were there in seasons 2 and 3?
I believe those were 12 episodes. Each, yeah.
So 34 episodes?
Correct. Yeah, correct.
So over the course of those 3 seasons, we're talking millions of dollars.
Yeah, not my strong suit, but yeah, that's like $1.5 million, something like that, Brooke.
Okay. I don't think math is your strong suit.
It is not I'm sorry, it's not.
Now, Mr. Cordillo, do you have any idea how much of that money would have to actually be set aside for the children?
I do actually.
How do you know that?
My son was in a commercial, a nationwide commercial, when he was 5 years old. I was shooting the commercial, and so then I was able to get him in, which is great. But it was a significant amount of money. It was a Super Bowl commercial. And so I was told we had to start a thing called a Coogan account, which is, that you create a fund that isolates the money from the parents. So when the kid turns 18, they get that money. And interestingly, I thought it's 15%.
I'm sorry.
15% is what they need to
Put aside.
Yeah. But I actually thought it was the opposite, and I put 85% in the Coogan, thinking, because it was shocking to me that parents can take 85% of a child's income, which is shocking, right? So it was so absurd to me. I put 85 in and not the 15. So.
And so the parents get to keep, if they choose, 85% of the money that their children make.
It's considered income, but yeah, they can spend it as they will, and there's no rule against it.
Okay. If I could have one moment, Your Honor. That's all I have.
Okay. Ms. Brandenburg-Koch, do you have any questions for Mr. Cordillo?
I do, Your Honor.
Awesome. Can you spell your last name for me?
It's Caldillo, C-A-U-D as in Denver, I-L-L-O.
Got it. Thank you.
Yeah.
Good afternoon.
Hello.
It's my understanding that you wrote an affidavit,
I did.
and when did you write that?
I believe it was the 13th
Of January?
of January, yeah. I believe. I'm sorry, I don't have a copy of it, and I'm not great with dates either.
That's okay.
I'm not working, so, every day is just today.
That's okay. If you need a copy, I have one if you need to see it. So you stated, and in your affidavit, that you were with Mr. Busfield 100% of the time.
On set, yes.
On set. So did you see him tickling and picking up the boys?
I never saw him tickling or picking up the boys.
You know that he did say he did tickle the boys
I
and
think
got
it was
them ready?
in the complaint, but yeah. But I never saw him tickling or picking up the boys.
Also, you, in your affidavit and just now, you stated that the dad of the victims, you had some concerns about him.
Yeah, he just felt weird to me. He was kind of creepy, to be honest with you.
And that you didn't like that he had his boys hug you.
He had his boys hug everybody. And so I just thought that, again, that this is just my personal belief about how I raise my children, which is that I wouldn't force my children to do something.
Okay.
That could be, it's just weird, so.
So did you continue to hug the boys when they came in?
I actually
on you?
rarely hug the boys. I would always I would do a high five or, just do like as simple as I could. Again, he's a parent. He gets to choose how he raises his children. I am uncomfortable with that.
Did you tell him that you had concerns saying, I don't want to hug your boys?
Again, he's their parent, and I trust that he's doing what he feels like is the best he could do. I have concern with that.
Right, but for you, since you didn't want them hugging you, you never told their father.
No, I didn't say I didn't want them hugging me. I just said I'm concerned that a parent would force a child to hug a stranger, like that. The child would say, "Hey, go hug that person."
Okay, but
I like kids. I like to hug kids, and I'm not saying I love my kids, and I love these little boys, and I wanted them to be happy and healthy, right? So, I'm just saying, for me, that was a concern for me as I looked at the father.
okay. Did you ever have discussions about that with anyone else on set?
No.
When did you read the criminal complaint?
Whenever it came out on deadline, to be honest, it came out on deadline, and I downloaded it and read it.
And who contacted you to write this affidavit?
Melissa, Tim's husband, asked if I would write something.
Tim's wife?
Correct.
Okay. And did you send that to Mr. Dodd's firm?
Yes, they contacted me and asked if I would do it, and I said yes. So I wrote it and sent. Actually, I think I sent it to Melissa.
Okay.
And then she forwarded it to.
And you are aware at that time when you wrote this that the defendant did admit to tickling the boys on set?
I'm aware that I'm sorry, could you rephrase that question?
You were aware.
I'm going to object.
Overruled. Go ahead.
Thank you. You were aware, because you read the criminal complaint,
Uh-huh.
that the defendant admitted to tickling the boys on set.
Well, it was in the complaint that he said he tickled him, yeah.
Nothing further. Thank you.
Okay. Mr. Dodd, did you have any other questions for Mr. Caldillo?
If I could have one moment.
Sure.
Your Honor, I don't have any further questions for Mr. Cordillo.
Thank you. You can go ahead
All
and
right.
take your seat. All right. And you want to switch over to Ms. Fairberg?
Your Honor, at this time, I'm going to hand it off to my partner, Ms. Fairberg, to make argument. Thank you.
I come with a lot of gear, Your Honor.
I see that.
As you know, we've all been busy this weekend. There's a lot of things, so I just want to be organized here for the court. Your Honor, I want to start with a presumption, not just in New Mexico, but in our system in general, and this comes from United States versus Salerno, out of the United States Supreme Court. In our society, and I quote, Your Honor, quote, "In our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception." That's based on the presumption of innocence that Mr. Dodd spoke about earlier, and it's echoed by Article 2, Section 13 of the New Mexico State Constitution, and of course, Rule 5409. This is in addition to the principle articulated in Gerstein versus Pugh that an accused may not be held absent a finding of probable cause. And Your Honor, I recognize that there's a finding of probable cause here by the Metropolitan Court judge signing the affidavit. But I actually want to encourage Your Honor to, in considering all of the evidence that was not available to that judge at that time, all of the pieces that were misconstrued in the complaint, as Mr. Dodd said, that does not appear to have been a neutral piece of evidence. I would actually encourage Your Honor to keep it in the back of your mind. Is there really even probable cause in this case? But setting that aside, what we in this state have required, have asked and required of the state of New Mexico is that they must prove both dangerousness and that no conditions, no combination of conditions could keep the community safe, that they have to prove that by the exacting standard of clear and convincing evidence. Now, as Your Honor is aware, there's a lot of evidentiary latitude in these hearings, but that's not a reduction of their burden. All of that evidence, whether it's via proffer, criminal complaint, things that wouldn't be admissible at trial, it still needs to be, according to the rule, reliable proof. It still needs to be reliable. And our Supreme Court in Mascareno versus Hadel has described that burden, clear and convincing, as evidence, and quote, Your Honor, quote, "evidence that instantly tilts the scales in the affirmative when weighed against the evidence in opposition." The state's nowhere near close to such an instant tilt. Not even close. And Your Honor, I'm not going to rehash every single one of the 5409 factors, although I will touch on them throughout my argument, but please let me know if you have a question about any one of them. But the state bases its motion on two: the nature and circumstances of the offense charged and the history and characteristics of the defendant. We just heard Ms. Brandenburg address the defense's concern that the state of New Mexico, both in public statements and now here in court, has acknowledged that, yeah, when they accuse someone of a crime against children, as a matter of routine, they file for pretrial detention. That's not what our law contemplates. This isn't meant to be routine. This is the carefully limited exception. And what we see is an approach that does not treat it as such. Basing the detention on charges alone is just not enough. And again, I want to read to you, Your Honor, from Mascareno versus Hadel, because our New Mexico Supreme Court has addressed this dead on, of whether the allegations, the nature of the charge, the statute under which a defendant is charged, is that enough? Is that enough for pretrial detention? And they tackle it head on, and they say no. And I quote, "To allow the state to rely solely on the nature and circumstances of the charged offenses, not only to prove that the defendant poses a future threat to others or the community, but also to prove that no release conditions will reasonably protect the safety of any other person or the community, would all but eliminate Article 2, Section 13, and the corresponding constitutional burden of the state." Close quote. We just heard Ms. Brandenburg say, yeah, anyone who's charged with a crime against a child is manipulative, cannot be trusted. There's no conditions of release that could possibly control that. And Your Honor, I would push back strongly on that. Not only because our Supreme Court has said explicitly, that's not how we do this. That's not how we do this procedure. But also, I think that really minimizes the power of the court, the power of pretrial services. The idea here and I just want to address this up front. The idea here, based on this pattern that the alleged pattern that I will address of brought forward by the state, what I understand they're saying is that there is an allegation that Mr. Busfield has, over the decades that he has been in Hollywood, has exploited his power for touching, mostly, by the way, post-pubescent adult women. So again, I think there's a disconnect here that undermines the allegations in this case, but that there is a pattern of doing that, exploiting his power. I think we need to acknowledge the reality of the world that we live in, that that power is gone. The state has canceled Mr. Busfield. His talent agency has dropped him. He's been edited out of a recent rom-com, a project that was just about to be released, not. He has no power. He is persona non grata, and that's not because he did anything wrong. As Mr. Dodd has very well said, he's presumed innocent. But that's because of the world we live in, and it's because that these allegations, this complaint, is not only all over New Mexico, all over the national media, it is all over the world. It's too late. That bell can't be unrung. The idea that he could then go out and be dangerous with a child in the world where everybody knows who he is absurd. That's absurd. Or that he could exploit power. He's not getting anybody any roles. He's not advancing anybody's career. And I think what this shows, Your Honor, is that the state is not acknowledging the individualized circumstances of the defendant, not acknowledging the reality, because what they're doing is they're proceeding as a matter of routine. So I just wanted to get that out there in the open. But now, Your Honor, I want to spend a little bit of time talking about these exhibits that the state has characterized as largely irrelevant, which I frankly find incredible. This evidence was compiled, as Mr. Dodd said, not by the state, not through some nefarious means by the defendant who's been in custody, but through a legal team, and mostly through people reaching out to us. Because again, this has been all over the global media. This is no secret. I don't know why this evidence is not portrayed in the criminal complaint. I don't know why this evidence has not been considered by the state of New Mexico. I'm frankly surprised, given the weight of this evidence. I'm going to say it outright, Your Honor. There is not a universe in which the state has the evidence, and we've received their discovery. We received it on Friday, as you know. There's not a universe that they could prove this case beyond a reasonable doubt. It's impossible. So the fact that we're here, again, I feel like we're in an incredible situation right now. So what this evidence shows is, one, the state's witnesses aren't credible. And although Ms. Brandenburg-Koch said that that's not relevant to the detention inquiry, yes, it is. Of course it is. Because, again, Your Honor has to base your decision on reliable proof. Well, if the allegations aren't credible, if the witnesses aren't credible, it's not reliable. The other thing that this pile of evidence shows is that the complaint itself isn't credible, meaning the actual four corners of the complaint. There are so many omissions, so many independent people coming forward to say, I've been misrepresented in there. And again, it's not, nobody's seeking these people out. And then finally, it shows that the allegations aren't credible. And I heard Ms. Brandenburg-Koch say a couple of times that the defense argument, the allegations aren't credible, doesn't hold water because the boys have never said that this happened alone. That's not true. That's not true. Again, this is a case that has had evolving allegations. But as we see in Defense's Exhibit I, Your Honor, the second Warner Brothers independent investigation, which directly addresses the allegations herein, but the state did not include or reference in its criminal complaint, specifically says, and I'll just go ahead, I'm going to skip forward, and I quote, Your Honor, from, again, that's Defense's Exhibit I. that the allegation was that Mr. Busfield had isolated the twins, quote, out of sight and sound, quote. That's the allegation. The fact that these allegations have evolved only makes them less credible. That actually, no, it wasn't out of sight and sound. It was where everybody could see it. It was, so I just want to put that out there now. I want to start with the criminal complaint. And Your Honor, I'd like to use my microphone here. I'd like to play, for Your Honor, Defense Exhibit Z. This is an audio-only clip of the first interview that police had with the boys in 2024. And Ms. Brandenburg-Koch has said, you know, it's not good practice to be asking kids questions before a safe house. I agree. And what this evidence shows is that there's been a good year and a half of their parents coaching them along before the safe house. So I agree. But this is in the beginning. This is the first time they speak. And so this starts with VL, Your Honor. And assuming that my technological prowess is not terrible, I'm going to play it for you right now.
And you know what's right and wrong, right?
Hold on, we're going to start over. And obviously, I'm not playing the whole interview, for Your Honor.
And you know what's right and wrong, right? You know where people can't touch, where people can't do. Yeah, you know that, right? Does Tim ever do that?
No, he's never touched me.
Never touched you?
Yeah.
In like, you know, your private areas, right?
Yeah.
Never did that?
Never.
Okay.
Let's go on, Your Honor, to Defense Exhibit AA. This is 5 minutes later, separate. The boys were separated. The same police officer, this time speaking to SL, out of the presence of his brother.
So, you know what's right and wrong, right?
Yeah.
You know no one could touch your private areas?
Yeah, but he doesn't touch them.
Doesn't touch your private parts? Okay.
That's not, Your Honor, a failure to disclose. That's an express denial. And the officer followed up just to make sure he didn't touch your private areas, because the conversation before, I'll express to Your Honor, the conversation before that was, you know, does Tim tickle you ever? And they said, well, you know, my shoulder sometimes. Do you like it? I kind of like it. I kind of don't like it. And then they went into the conversation about the private parts. This was not a failure to disclose. This was an express denial. And I want to talk, Your Honor, about the medical records that the state has referenced. We did not submit them as exhibits, but given the state's argument today, I would like to read a couple of pieces from it. And that is because the state's made the assertion that SL reported to his therapist unprompted and, you know, not to parents. It didn't come from parents. And what we see from the records is that's not accurate. It's not accurate. This complaint is not credible. This is from, I'm just going to read a portion. I'm going to read a few portions, but this one is from one of the very first notes. And in the room are SL, his father, Ronald Rodas, and the therapist. These are her notes. And I quote, "Father then told client that client needs to trust therapist and feel safe to talk about the abuse so that client and family can heal." Only after that did then SL say, okay, well, here's the abuse. This was not a spontaneous disclosure that happened with someone he trusted. This was in the presence of looking at dad. And the reason we know that is because there are other medical records that say, there are so many things, and I want to make sure I've got the right one for Your Honor. Okay. there's an allegation in the complaint that SL was having nightmares, suffering from PTSD from this abuse. Well, what the medical records show is actually he wasn't. He wasn't having nightmares. When his father is not in the room with him, when his father's not in the room with him, SL tells the therapist that he's waking up at night, and I quote, waking up at night due to being too hot or too cold. His father tells that client is having a nightmare when client wakes up, but client does not remember it. Multiple times throughout the medical records, multiple times, SL tells the therapist, I wake up because I'm hot. And then the therapist says, well, why don't you tell your dad that you're not having nightmares, that you're just hot? And then this is what he says to that. Client, quote, client feels the need to please his father and at times is scared to tell him what's going on due to fears of disappointing him. These aren't credible, non-exaggerated allegations. These are manufactured allegations. This complaint omits all of that history. But not only that, we know that it also misconstrues conversations with its own witnesses. I'd like to play for Your Honor Defense Exhibit S. This is a voicemail left, not solicited, left to the Busfield's family's personal attorney. This is a voicemail from her.
Hi, this is Danielle V. Hill. I'm reaching out regarding Timothy Busfield. I noticed that I was in the police reports for his warrant, and I was not very happy with how the detective twisted and used my words and just picked and choose what he wanted to put into that report. I don't feel comfortable with a man sitting in jail right now when I know what I said, and that's not everything or twisted words into the report. So I would like to be able to speak with someone about that because this has gotten kind of out of hand. So thank you. My phone number is 505.
We won't play her phone number for everybody, Your Honor. She's not the only one. States, Defendant's Exhibit, I keep saying states, Defendant's Exhibit L is an affidavit of Kristen Carr. She says the same thing. She says that the detective omitted from the criminal complaint things that she thought were crucial. That set teachers never left the boys unsupervised, that there were always 20 to 30 people in the room, and that she never saw the kids ever alone or somewhere where other people could not observe. But now let's get to the crux of it, because this is something Ms. Brandenburg-Koch talked about, the parents here, the parents. The issue is not that people with a criminal history cannot be the victims of crimes. That's not what this is. That's not, oh, there was a DWI here or there was a conviction back there. That's not what this is. I think I'll say it the most simply. These two parents have a documented history. They're con artists, actual con artists. Ronald Rodas, Defendant's Exhibit A, the DOJ's press release. The DOJ's press release after he was convicted of wire fraud, defrauding 1,500 homeowners during the mortgage crisis through a sham law firm of over $6 million, served 3 years in prison, and was disbarred in the state of California. And this is what the DOJ says, and I quote from Defendant's Exhibit A. It is an unfortunate truth that people often take advantage of a crisis for personal gain. The Rodas Law Group was among the worst type of scammers, trying to take advantage of homeowners already experiencing profound heartache in the face of potential foreclosure. I didn't make up the word scammer. That came from the Department of Justice. And Angel LaSalle was no better. Defendants Exhibit E and F, that's a lawsuit, a civil lawsuit. Again, not just some unrelated unrelated idea. This is about stealing. This is about defrauding people. Had a Bentley, sold it for $90,000, didn't turn over the title, had the car unlawfully repossessed, and then fraudulently traded it in for a Porsche 911 in her mother's name. And that's in addition to a domesticated judgment for over $75,000, well, including penalties, but a $75,000 judgment for bad checks written at the MGM Grand in Las Vegas. Again, these aren't unrelated. So why? I mean, I guess the question here is, if the boys said that this never happened, why are we here? And we're here, it's documented through these witnesses. We're here because those boys lost their role. They lost their role, and exhibit after exhibit talks about, we've got Defendant's Exhibit I, the Warner Brothers investigation, which describes the star of the show, Elodie Young, who was close with the family, saying that after Ronnie and Angel found out that their kids would be recast, actually used the words, they would get revenge on Tim Busfield. We've got the affidavit of Chris Ford, Defendant's Exhibit K, which says the same thing, that he, while out at a dinner with an actress and the family, they were upset. They were visibly upset that the boys wouldn't be back on the show. And same thing, she said she'd get him, quote, have his ass, unquote. This entire criminal complaint is making good on that promise. And to address Ms. Brandenburg-Koch's idea of, well, you don't get money from the criminal process. No, it also wasn't their first stop. They got a civil attorney first in California, who then interacted with Warner Brothers. They didn't contact police, again, until after Warner Brothers in September of last year came out and said, there's nothing behind these allegations. Translate, we're not going to give you any money. Then they went to police. There are other ways in which the complaint mischaracterizes what happened. The idea that Mr. Busfield told these kids to call him Uncle Tim. Both the independent report, Exhibit I, no one ever heard him being called Uncle Tim, except Miss Young, who said she heard Ronald Rodas say, go hug Uncle Tim. That's consistent with what you heard here from Mr. Caudillo. Exhibit N, affidavit of Joe Lotito. Never heard anyone say Uncle Tim. Exhibit BB, this one was just submitted last night. And I quote, she also said that Mr. Busfield never asked to be called Uncle Tim. And I quote from her, I also had the opportunity to observe the twin children referenced in the case and their parents, Angel and Ronnie. I observed the twins' father, Ronnie, telling his children to hug adults on set, including Mr. Busfield. I never saw Mr. Busfield initiate one of these hugs and never heard anyone call him Uncle Tim. Contrary to the allegations in the complaint, Mr. Busfield was not, quote, touchy on set and instead appeared focused and professional, close quote. And finally, Exhibit O, Copper Perry, head of the hair department, same thing. Never saw anything creepy or touchy. The allegations continue to fall apart. And this is under the idea that we've already discussed a little bit, this idea that they are impossible. It's not just Exhibit I. It's not just the independent investigation, which, as Ms. Brandenburg-Koch characterized as minimal. I don't know why she's using that term, considering they interviewed, I believe, 9 to 12 witnesses over a several-week period and came out with a comprehensive report. I don't see how that's minimal. But in addition to that, Exhibit K, Chris Ford, that someone always had, quote, eyes on Tim Busfield because he was the director. Also said he didn't have his own trailer. This idea that he was causing trouble in his trailer. He doesn't have a trailer as the director. Exhibit L, Kristen Carr. The kids were never alone, always 20 to 30 people around. Exhibit N, Joe Lotito. Kids were never left by the set teacher. He says, and I quote, it is inconceivable to me that the alleged conduct could have occurred on set because of the number of crew that are always around and working. Close quote. Exhibit O, Copper Perry. The boys are always accompanied by a set teacher, never alone. And this is in addition to their parents. There's set teacher, there's also their parents around. The photographs that are referenced in the complaint, which are, I'll tell Your Honor, Mr. Busfield is standing behind the boys, has his arms a little bit around them, and you can see that he's kind of tickling their shoulders. I do the same thing with my kids to get them to smile in a photo. And who else is in the photo? Their mother. This isn't the idea that they discovered these photos later. They took the photos. They were in the photos. And then finally, something we haven't heard from the state at all, it's Defendant's Exhibit P. These are other parents, Erica and Adan Ortega, parents of a child actor who had no concerns, but also said there's always supervision and that they can always observe from monitors, that basically they're never alone. And finally, Exhibit Q, the same thing. The parent, this is the parent of the child that replaced SL and VL. The kids were never alone, said it was a great place to work. The only issue was that they were getting abuse online from family members of the LaSalle and Rodases. And then same thing, Exhibit R, Deborah Toner, her affidavit, quote, I never observed unaccompanied minors. All minors on set were always accompanied by an appropriate supervising adult. And then, Your Honor, we've got the polygraph. It does matter. It does bear on this proceeding exactly. Because again, if the allegations never happened, we can't detain him. You can't detain him if we say, okay, this probably never happened. There's probably not even probable cause for it, but we do have some unfounded, some as yet unsubstantiated allegations dating back 1991, 1994, again, all with post-pubescent or adult women. No bearing on this case. That's not how the law works. We can't say, well, it doesn't matter if he says he didn't do this. Yes, it does. It absolutely does. The bottom line, Your Honor, is that the overwhelming evidence is that this didn't happen, is that this was manufactured, and there is a credible story here, and it's a very sad story, and there are victims, and they are still these two boys, but they weren't victimized by Tim Busfield. They were victimized by their own parents, who no longer could make money as a lawyer, disbarred, no longer could write bad checks, taking 85% of the money they made on a TV show and then manufactured into victims as revenge. That is what the evidence shows. And I realize I'm running out of time.
You are. So I'm going to push you. You've got 3 minutes left. Are there any of the
Your Honor.
other F6 factors you'd like to address?
One thing I didn't do, Your Honor, was address the history, the alleged history. And I did a little bit. I do encourage Your Honor to look at Defendant's Exhibit Y. I'm sorry, it says Plaintiff's Y. That was me. Okay. Mr. Dodd would never make that mistake. That's me. That's the affidavit by Matthew Moore, where he talks about that, this was another parent pushing forward on their kid's career. I'm going to go fast. You've seen the public safety assessment. You've seen the ABLE assessment. That is absolutely relevant. It's absolutely relevant because it says he's no risk. So I ask Your Honor, what the state offers is narrative. What Rule 5409 demands is reliable evidence and evidence that points decisively toward release. That's what the evidence points toward right now. The LaSalle Rodas family has already gotten its revenge. Mr. Busfield has been canceled. His career is over. In the span of 6 days, it's done. Edited out of projects, talent agency dropped him, allegations plastered all over global media of pedophilia, his wife under attack. His life is ruined, but his liberty under the rules, under the Constitution, under the facts of this case can be restored. And I ask Your Honor to restore that liberty. And you've got 3 ways to do it. 1, there's no evidence of dangerous, certainly not clear and convincing. There's definitely not clear and convincing evidence that no combination of conditions could keep the community safe. And finally, I ask Your Honor to reconsider the probable cause in this case, because then it would be patently unconstitutional to hold him. He should be released on his own recognizance. But even if Your Honor has any hesitation at all, well, that's easy. That's easy. A no contact with kids order. House arrest here in Albuquerque. He doesn't have a community in Albuquerque. He has no power. There's nowhere to go this idea that, there's no way for the court to know if people charged with these kinds of crimes can talk to children, that's not how our courts function. We function on the presumption of innocence, and I ask Your Honor to please restore Mr. Busfield's liberty. Thank you.
Thank you, Ms. Fairburn. Okay, let's turn back to the state, Ms. Brandenburg-Koch.
Judge, can you just let me know how much time I have?
10 minutes.
Judge, again, I want to make this very clear of what we are here on today. We are here to see if the court agrees that the defendant is dangerous, and if there are conditions the court can set, which the state's argument is there are none. Defendant's exhibits and argument here don't talk about what this case is about. They're trying to fluff, use the parent's history, and that's why these victims, essentially they're saying, are liars and are going to, and they're being coached, even though.
Sorry, that was my timer for Ms. Fairburn.
At least it wasn't me.
You need to find it. You did.
Thank you, Judge.
Sorry about that.
It's okay. It's okay. There was medical concerns about sexual abuse prior in November of 2024 made by the doctor after seeing the kids in this case. So how this even started was because a doctor, in his experience, was concerned. Not because of anything else besides what he thought and what he saw during presentation of the kids. I've already laid out, and I know the court is very aware of how kids disclose abuse. This is the norm. It is not shocking to the state that they didn't disclose to police right away, especially when the questions were inappropriate. They were leading in everything that best practices say how kids should not be asked questions. For defense to get up here and say that their disclosures of sex abuse aren't credible because of the parents, even though they have continued to show signs and and continued to disclose the abuse all very similarly, is what is here in front of the court. Again, this isn't a mini trial, and yes, the court can judge credibility and the weight of the evidence. However, this is one factor. Of course that's an easy defense to say these parents are liars and they're coaching their kids, and this could never happen. Even though there was concerns back in November of 2024, there was concerns again at therapy when the boys disclosed, there was concerns again with another medical professional, there was more concerns at Safe House. So this isn't a one-time disclosure where parents are telling them what to say. And I know the court is aware about coaching and how difficult it is to coach a child at that age and to continue and remain consistent. Kids are at this age, very black and white. To then say, oh yes, I'm gonna lie and exactly how my parents told me to say it, even though they were able to give details of how he touched them. They corroborate the defendant's statement that, yeah, he did tickle them all over, which I think is important because defenses, all of their exhibits contradict what the defendant also already admitted to, that this conduct could never happen and nobody saw anything. The witness himself said, I was with him 100% of the time, but never saw this tickling or touching, even though the defendant himself said he did it on set and getting them ready to act. So that is not reliable when the defendant's own testimony, own statement to police is that he did in fact touch them. And if defense wants to say that the civil suit is the standard here, the defendant also has a civil suit, a sexual assault civil suit. It shows a pattern. It shows a history of his characteristics. The defendant is famous, wealthy, influential, as you can see by all of the exhibits provided, which all these character witnesses, these 87 letters he was able to get in 7 days. The victims, the way that these cases are brought forward is by what victims say, not what their parents are telling the police. And we have to, if there's other credible evidence that their disclosures are credible, we move forward. I don't get to discriminate because they have a history, and neither should this court. The victims are little boys. They didn't have power. They didn't have money. They don't have influence to get all of this support to show how they're not lying. Why? It's not only the defendant's reputation. Defense has leaked all of these exhibits and has gone after the parents to show this narrative that it's all the parents making this up. The boys at 11 years old can't even comprehend how to get revenge and what this would do, and why put themselves in a position to be criticized, to be called liars, to continue to go through trauma. They were diagnosed, and very much so, therapists know about coaching, and if the therapist had a concern about coaching, would have put it in her note and would have disclosed that to the detective as well. There was no indication that she was concerned about coaching. Neither was there concern about doctors thinking there was coaching going on by the parents, by professionals that know how children disclose. Abusers, especially people that go after people that don't have a lot of authority, children, people that, are employees or work on a set, they take advantage of this very dynamic. No one's going to believe them because they have this history. They're kids. They delayed disclosed. Most importantly, defense has not shown or argued at all that there are conditions of release. House arrest is not a condition that can secure the community. You have 87 letters in front of you, with most of them saying, I would trust him, he would do this, I would trust my kids with him. So you can't tell those people they can't come over with their kids. And we know that they're not going to come forward and say, oh yeah, I did let my kids around them. House arrest is not a proper remedy when we're talking about conditions of release here. There is enough. Probable cause has been found twice in this case already. The boys have continued to disclose, have cooperated, despite them being dragged through the mud in this case. And this is only the beginning, as the court knows. This process is not easy for a victim, let alone for young children. And most importantly, all of their letters go against the reasons why he should be released. That support shows you his power, his influence, that will continue and allow for this behavior. And most importantly, under State versus Begay, is the court has to decide, despite other factors and the risk, is the court willing to take the risk that this could impact the community again? And there is nothing besides the state showing the history of the defendant that weighs for why he should continue to be held. They have proffered no information that he'll comply. In fact, what he has shown is that he will comply when he wants to, when he's ready, what benefits him. And I'm asking the court to hold the defendant because those risks are real, and his history shows this court that those risks are real. There are no conditions that this court can set to make sure anybody in the community, anybody in New Mexico, anywhere, that this danger wouldn't happen. The court can't make pretrial do any of those for the concerns in this case. And I'm asking that the case hold the defendant pending trial. Thank you.
Thank you, Ms. Brandenburg-Koch.
Judge, I'm so sorry. I do want to address the target letter. The target letter has been sent. Mr. Dodd has had access to that since the 16th of January.
I'll trust you guys to share that here. Okay. Okay. The court will find and rule as follows. The question is whether or not the state has proven by clear and convincing evidence that there are no release conditions that would reasonably protect the safety of any other person or the community. It's broken down into the three-part analysis articulated in State versus Groves, and in that analysis, the court considers the factors enumerated in Rule 549F6 as required by State versus Anderson. The first question is whether or not the information proffered carries sufficient indicia of reliability to be worthy of consideration. I do find that the state's 6 exhibits and the defendant's 28 exhibits and the court's 2 exhibits and the testimony offered today are reliable for purposes of this decision. The next question is the dangerousness question, the extent to which that information indicates that the defendant may likely pose a threat to the safety of others if released pending trial. I'll back up and note that probable cause was found by the Metropolitan Court judge. We're not set for a preliminary hearing today. I do find that that is sufficient for a probable cause finding for today's purposes. So as to the dangerousness question, based on the nature and circumstances of the present offense, noting that this is a crime where the allegations involve criminal sexual contact of minor children in the genital areas, I do find that is inherently dangerous. So I'm satisfied based on those that the state has proven that Mr. Busfield does pose a danger to the safety of others. As to the last question, whether there are any potential pretrial release conditions that would reasonably protect the safety of others, I'll work my way through the F6 factors, first adopting my findings about the nature and circumstances of the present offense. I'll move on to the weight of the evidence. Now, Ms. Brandenburg-Koch is right. It's important to acknowledge the nature of sexual assault cases, and delays in reporting, especially from minor alleged victims, are fairly common. That sort of sexual abuse often occurs in the dark. This situation is a little different in that the allegations involve the defendant being alleged to have committed these acts on a film set. Now, the defendant's presentation, the affidavits from a number of people who worked on that film set, the independent investigation performed by the law firm hired by Warner Brothers, The testimony offered today do not corroborate the allegations offered by the alleged victims in this case. Now, while true, the statement from those children to law enforcement initially and expressly denied that anything occurred, the children then subsequently reported these things. That's not uncommon. As it stands today, based on the limited information I have in front of me, I'll characterize the weight of the evidence against the defendant as neutral at this point in time. As to the defendant's history and characteristics, as included or reflected in Court's Exhibit 1, this defendant exhibits 0 criminal history, no misdemeanor or felony history. The state has brought forth a number of allegations over the last 30 years, something of a pattern involving allegations of this defendant committing some sort of sexual contact against post-pubescent women. Now, these allegations have not been vetted by the judicial system for various reasons, there being a civil settlement in one of those, a declined prosecution, or no action taken on the exchange of the defendant engaging in therapy. I understand that given the media attention to this case, that more people may come forward with other allegations supporting this pattern. But at this point in time, it's difficult for the court to put too much weight into those allegations as they've not been vetted by the judicial system. I'm concerned about the allegations of this defendant using his position of power on the film set to advance his own personal motive. But the affidavits offered by other people working on the film set do not show that Mr. Busfield has used or abused that position of power. With regards to the nature and seriousness of the danger posed, I'm very mindful of the higher court's guidance in the Begay case in weighing this defendant's risk of reoffending. But given the lack of a pattern involving children in this case, I think that can be remedied through different conditions of release. For factor E, I don't find that there's been sufficient presentation that this defendant may commit new crimes if released pending trial. There's no evidence of a pattern of criminal conduct. There are no similar allegations involving children in his past. There's no evidence of noncompliance with prior court orders. Rather, this defendant self-surrendered and submitted himself to this court's jurisdiction, demonstrating compliance with the court order for his arrest. There's not been any prior pretrial detention finding. So on the balance, I cannot find that the state has proven by clear and convincing evidence that there are no release conditions that would reasonably protect the safety of any other person in the community. So I am denying the state's motion. I'll take care of that order. That'll be published tomorrow. So Mr. Busfield, I'll set the following conditions of release. You're authorized for release on your own recognizance with the conditions that you appear at all future court settings, you not violate any laws. You'll be supervised by pretrial services here in Albuquerque at a level 2. I'm not going to prohibit your travel. I understand you may not live here, but you will need to report to pretrial services here. You're not to possess any firearms or dangerous weapons. You're not to possess or consume any alcohol or illegal drugs. You must notify the court of your address. You're not to have any contact with the alleged victims or their families, and you're also not to discuss the case with any witnesses. That's what the attorneys and their investigators are there to do, and we can't have you tampering with any of that. And then you need to maintain weekly contact with your attorney in this case. So, Mr. Busfield, do you have any questions for me about what any of those conditions mean?
No, sir.
Okay. So, attorneys, I'll take care of that order tomorrow. Is there anything else the state would request, Ms. Brandenburg-Koch?
Good. I would ask for no contact with children under the age of 18.
Oh, yeah, sorry. No unsupervised contact with any minor children in this case. Mr. Dodd, any other conditions you'd request?
No, Your Honor, I would ask just if the court can get that filed through your TCAA today so that I can.
Oh, the conditions of release? Yeah.
Yes.
I've already, yeah.
Perfect.
That'll be filed today.
Thank you.
I'll take care of the full detention order tomorrow. And so with that, anything else, state
Not at this time, Your Honor.
and defense?
No, Your Honor, thank you very much.
Okay, thank you all. We'll be adjourned.
Thank
That's what I knew that. That's fine. I just want to make sure you guys have the target letter.
We did not receive it on this.
No, it's in,
When did you guys send it?
we sent it.